Now, Mr. Corby.
My Lords, I was just about to begin my submissions on why I say, as a matter of construction, the contract contained an agreement to agree. And I wish to make two broad points on that. The first is that as a matter of the natural and ordinary meaning of the words open price to be fixed, construed into the remainder of, in light of the remainder of clause 5 in the relevant category matrix, leads to that result. And I'll address your Lordship's question from before lunch when dealing with the language of the open price provision. As to that, my Lords, it may help to have a copy of the contract at page 191 turned up for these submissions, and I wish to make 4 points about the language. The first point is that the open price provision refers to the 800 metric tons being at an open price. And in my submission, the natural and ordinary meaning of an open price is one that has been left open to be agreed in the future. It can be contrasted with the fixed price that is set out as having been agreed already for the 400 metric tons per year in the immediately preceding paragraph in clause 5. If the parties had meant that the open price to be fixed was to be a reasonable or market price, they would have used those express words. They would not have used the words open price, which indicates that there are no criteria or benchmark for fixing the price, absent agreement. It's all open. It's wide language. Second, my Lords, the open price provision goes on to say that the open price is to be fixed, and in my submission that meant to be agreed. As to that, that is clear from the use of the word fixed elsewhere in the contract. The word fixed is used in clause 5 and clause 3 in respect of the price for the 400 metric tons. For example, one sees in clause 3 that has been fixed is 1350 euros per metric tons, and likewise in the second paragraph of clause 5, fixed at 1350 euros per metric tons. And that was a price that the parties had agreed. There's no suggestion that that was a reasonable or market price, instead of one they had freely negotiated and agreed between themselves. So when they referred to that price as a fixed price, they meant one that had been agreed, and it must follow that when the contract spoke of the open price as something to be fixed, that also meant something to be agreed between the parties. The parties must be presumed to have used the language, and in particular the verb to fix, consistently throughout the contract. Further, as a matter of normal usage in the context of shipping and commodities contracts, fixed is a common term to mean agreed. For example, when a fixture recap for a charge party says the parties are clean fixed, it means they have agreed. And this is true in the sale of goods context. If I may make this point by reference to May and Butcher, I could ask your Lordships to turn to tab 7 of the authorities bundle. And at page 41 of the authorities bundle, 17 of the report, about a third of the way down the page, just below the first hole punch, we see the clause in question, and that is clause 3. And the clause there provided that the price for the tentage shall be agreed from time to time. So it used the language shall be agreed. If your Lordships turn forward to the speech of Lord Buckmaster, where there's a line in the margin, when referring to that clause, Lord Buckmaster says there was an agreement for the sale of the goods. There was an agreement that the price for the goods should be subsequently fixed between the parties. In other words, my Lord, demonstrating that to be fixed is well understood and well used as a synonym for to be agreed. Hence why Lord Buckmaster used those two phrases interchangeably. My third point is to the language, my Lords, is that the open price provision required the open price to be fixed latest by December of the previous year. It did not provide that the open price was to be fixed as at December of the previous year. The words by December only set the endpoint by which the open price was to be fixed, which therefore permitted and so intended that it might be fixed at an earlier time, namely by the parties' agreement. Conversely, if the intention had been for the price to be set by some external benchmark, without regard to the parties, it would have been apt to say this was to be done by a deadline, but rather at a particular moment in time. telling you at what moment one was supposed to have regard to this objective benchmark. My fourth and final point on the language arises from clause 3 of the contract, which is further up the page on page 191. The third sentence provides free trucks will be offered from the seller according to the agreed volume and price of each year. The word agreed in that sentence describes both the volume and the price. The natural and ordinary meaning is that both of those had to be agreed. As to the 400 metric tons, the price had already been agreed, it had been fixed, and this meant that the volume for that part of the contract had already been agreed. 400 metric tons plus the volume of free trucks necessary to make up the difference between the invoice price and the fixed price, namely 74 metric tons. That had all been agreed. As to the 800 metric tons, however, the parties had yet to agree the effective price for that, and so the parties had yet to agree the volume of free trucks necessary to make up the difference between the invoice price and whatever price was agreed. And that is why clause 3 recognised that the parties left the open price for 800 metric tons to be agreed, and hence the volume to be agreed, and that's why it used the word agreed. Those are my submissions on the language. I now wish to turn to the remainder of clause 5 and the relevant factual matrix. The rest of clause 5 confirms that the open price was something to be agreed and that it was not somehow meant to be a reasonable or market price, for two reasons. First, as I've already said, clause 5 provided that the open price was to be fixed latest by December of the previous year. So what that meant is that by December of the year before the year in which deliveries were to take place, whether by the beginning or the end of December doesn't matter for present purposes, the open price for the 800 metric tons had to have been fixed. Further, the factual matrix shows that this was not an arbitrary deadline, the breach of which would have had little consequences for the parties. It was an important deadline with important practical consequences. The reason for the deadline is explained by the following four features of the factual matrix found by the judge. 1. The peak production period for pulp wash in Greece, which is where the pulp wash sold under the contract was to be produced, is from December to March. That's paragraph 7 of the judgment. 2. Pulp wash has a limited shelf life of 12 months from production. That's paragraph 7 again. 3. Sellers need to plan production and buyers need to identify uses for pulp wash in advance.
Just say that again, sellers need?
Sellers need to plan production.
Yes.
And buyers need to identify uses for pulp wash in advance. That's paragraph 51 of the judgment. And for that reason, contracts for the sale and purchase of pulp wash are normally concluded before production. And again, that's judgment 51. As a result of those four matters of background, the reason the open price had to be fixed latest by December of the previous year was therefore so that KSY would know how many free trucks it would have to produce in its peak production period, i.e. December to March the following year, and Citrosuco would know how much pulp wash in total it would be receiving in the following year, so that it could plan to utilise it before its 12-month shelf life expired. In other words, the deadline to fix the open price was linked to the window in which KSY would have had the opportunity to produce the pulp wash. There was thus a very good reason why the open price had to be fixed by the deadline in clause 5. The party cannot have contemplated otherwise. My second point on the remainder of clause 5 concerns the provision providing for the difference in price to be provided in free trucks. Pausing there, as my lordship has already noted, a provision for the difference in price to be made up in free trucks appeared twice in clause 5, once in respect to the 400 metric tons and again in respect to the 800 metric tons. And I've already shown your lordships earlier at paragraph 118 how the judge explained those provisions were to operate in both cases. As to the 400 metric tons, KSY was to provide the free trucks on top of the 400 metric tons to reduce the effective price to the fixed price. And as to the 800 metric tons, the provision was to work in exactly the same way, save that the free trucks were to reduce the price to whatever the effective price was that had been agreed. If I may ask your lordships to look at paragraph 116 of the judgment, which is at page 113. The judge set out in a little bit more detail his construction of the free trucks mechanism. In so doing, he rejected the evidence of Professor Katoupis, or at least rejected the way Professor Katoupis had understood it as a gentleman's agreement, or was the way it operated in this contract. What I'm interested in is further down, about 4 or 5 lines up from the bottom, starting on the right-hand side of that paragraph. The judge explains that the amount of free trucks to be delivered flows inexorably from the price, as the contract anticipates would have been agreed as indicated earlier. In other words, the parties were required to agree the open price for the 800 metric tons, and if they did so, the number of free trucks would follow as a matter of calculation. The judge did not hold, however, that the provision for free trucks was somehow a vague reference indicating that the open price was not something that was to be agreed, but was instead to be set by some reasonable or market mechanism. That is not how the judge construed the mechanism. As for the reason for adopting such a mechanism in the contract, as the judge noted at paragraph 10, KSY had indicated...
Sorry, paragraph 10.
Paragraph 10.
Just a moment.
KSY had indicated that it was using...
Let's get the page. Paragraph 10 of the judgment.
Judgment, yeah.
Page 83.
Page 83.
Yep.
Three lines down, the claimant through its witness indicated that it was using invoice factoring, and it may well be that the use of a fixed invoice price assists with that kind of invoicing, with that kind of factoring. And in my submission, that is the obvious purpose behind the free trucks mechanism, is to factor your invoices at the invoice price, but accept that you're going to have to agree a different effective price in the future.
What do you make of his first sentence?
Yes. The first sentence has to be read in light of paragraph 9. Paragraph 9 is where he sets out Professor Katoupis's understanding of the free trucks mechanism, which he goes on later to reject, that this is some act of goodwill by a seller to keep a buyer happy and give it some extra free product. And then turning over the page, what he's saying in the first sentence of paragraph 10, and I assume your lordship is referring to the language at least as deployed here, what he's saying there, my submission, is at least as deployed in the sense that Professor Katoupis has explained and I've set out in paragraph 9. The invoicing price remains constant and the delivery of the volumes will vary according to market conditions, because that's exactly how he's described it in the previous paragraph, in paragraph 9.
What, so he's not talking about this case?
No, he's not talking about this contract. That's obvious from when he goes on. He's as deployed here, and he's as deployed in the manner explained in paragraph 9 by Professor Katoupis. And to make that good, my lord, if your lordship turns forward to paragraph 46, which is at page 92, the judge then goes on to deal with Professor Katoupis's understanding of the free trucks mechanism in a little bit more detail, noting that on this understanding it's an unwritten I should say unwritten rule, or a gentleman's agreement, and there's no contractual entitlement in the buyer to receive free trucks. Essentially, if a seller wants to be benevolent, keep a buyer happy, it can give them some more product if the market is against the buyer. But the key bit, my lord, is the paragraph I've already shown you, lord, paragraph 116. This is the part of the judgment where the judge deals with the way in which the free trucks mechanism is used in this contract. And he rejects Professor Katoupis's evidence that the free trucks mechanism does not bear on the price, and then goes on to say it's simply a matter of arithmetic, that the parties will agree the price, and the free trucks will flow inexorably, as he says, from the price as the contract anticipates would have been agreed. So, my lord, I do say in paragraph 10, where he says, as used here, that is a reference to the way it's being described. He's not at that part of the judgment dealing with the contract. He's setting out some introductory matters, but when he comes on to deal with the construction of the contract, paragraph 116, he rejects the notion that this is a gentleman's agreement that the seller will offer additional free product.
Can I just go back to the concept of invoice factoring? I don't really follow how this mechanism assists invoice factoring. The invoice takes place at the same time as delivery. I think the contract is silent as to when it's going to be paid. Assume that it's sometime in the distance, so that there's some factoring to be done. At that stage, it will, depending on the quality, it will invoice at somewhere around 1600. It may vary, plus or minus 5 bricks, 5/60 of that. But it'll identify a price, which won't be the real price because there are a lot of free trucks. How does that help factoring any more than if it stated the real price?
Yes, well, as I say, there was limited evidence on this. It was the claimant's witness who revealed that factoring was being used. As I understand the mechanism would be, is that the appellant will know that it can factor 800 metric tons at 1,600 euros per ton for the year. So it may be that it's more a factor that affects the appellant's planning of its financing. It knows the financing it will be able to obtain, regardless of the price it actually agrees, because it's going to be able to go and say, here, I've issued these invoices, subject to the bricks value, they've been adjusted, but give them to the bank, factor the invoices on that level, and then the appellant will have its stream of income or its stream of borrowing based on that factoring, regardless of the fact that it's then going to go and say, well, realistically, with you, Citrosuco, I know you're not buying it at this price, we're going to give you lots of extra products so the effective price is lower. But that's how, as I say, there was limited evidence about it, but that's how I understand this mechanism could work.
Can I go back to the other point you were making, which is about the use of the phrase "at least as deployed here"?
Yes.
You say you say that doesn't. He's not there describing what was actually happening under this contract.
No. And I say that because of this is an early part of the judgment before His Lordship came on to the contract, which is later. He sets out in general terms the claimant's or the appellant's expert's understanding, as I say, as a gentleman's agreement. But then later on at paragraph 116, when he is construing the contract, he goes on to say that it doesn't work like that it's not a gentleman's agreement, that the amount of free trucks flows inexorably from the price that the parties will agree. And so that's why in my submission, the as deployed here, read in the context of the judgment, is just referring back to the evidence of...
Well, which part of the first, the Lord raises a moment ago, which part of the first sentence of paragraph 10 does not apply, you say, on the facts of this case?
So the second part where it says, and the delivery volume varies, I agree with that. This is the bit that doesn't apply, according to market conditions, because what the judge held at paragraph 116 is the delivery volume varies according to the price the parties have agreed. And he rejects the case put forward by Professor Pearce, that the free trucks mechanism is designed to work when you have a situation where one party is doing badly because the market price has changed, the buyer's doing badly, a benevolent seller may, as a gentleman's agreement, offer more free truck to reflect the fact that the buyer is now paying too much.
The gentleman's agreement point doesn't appear in paragraph 9. It's a later point. I mean, he rejects that later on, but that's not part of the evidence he's dealing with now, or the understanding which he says the parties had in this case.
Yes, pausing there. There's no distinction between Professor Pearce's understanding of paragraph 9 and the way the judge deals with that later. And this is the same free trucks mechanism being put forward by Professor Pearce. And you get that from the third sentence, where he says it's a promotional pricing strategy. Promotional in the sense that this is the seller offering free product to a buyer to keep the buyer happy. That's what a promotion is. He expands on it later at paragraph 46, where he says, well, now I've heard cross-examination on this. It's very clear that Professor Pearce understands it as some sort of gentleman's agreement. And then I say he comes to paragraph 116 and he says, well, it doesn't work in this way. It works for the 400 metric tons and the 800 metric tons, simply to adjust the difference between the invoice price and whatever price is either agreed at the outset for 400 metric tons or agreed later for the 800 metric tons.
So he's rejecting the bit in italics in paragraph 9, which is quoted, which ends, thus aligning the price of the goods with the current market conditions.
Yes.
He quotes that. He says that is what the parties in this case intended, and then says the result is that the invoicing price remains constant and the delivery volume varies according to market conditions. That all makes sense if he's talking about this contract. But you say he's not talking about this contract.
No, my lord. I say the answer to that is paragraph 116, where he says, insofar as it might be suggested in accordance with Professor Katupis' evidence that the free trucks mechanism did not bear on the price because it's just a promotional pricing strategy, I do not accept this.
Yes.
And just turning to the understanding, my lord, at paragraph 9. The final sentence, however, there seems no reason to doubt that Mr. Landsberger and Mr. Caden each understood it to mean as defined by Professor Katupis. The starting point is that there was no evidence from either of those individuals, and their subjective understanding or knowledge would be irrelevant and inadmissible. Even so, the judge didn't make a positive finding that that was how they understood it. He just said he didn't doubt that that was how they would have understood it, which is not surprising in certain sense, but he had no evidence on that point. And even if he had found that there was a subjective understanding in those terms by each of those individuals that had crossed the line, again, I say that would be inadmissible. And the judge himself made that point at paragraph 29 of the judgment, where he says, I agree that in terms of contractual construction, the subjective thoughts of the negotiators, even if shared, would not be admissible. That must be a reference back to paragraph 9. And in any event, we know that one of those individuals actually left Citrosuco before the contract was signed. He left in the summer of 2018, and the contract wasn't signed until much later. So I do say that whilst the judge set out in his introductory section the background provided by Professor Katupis on the way he understood the free trucks mechanism, which was trying to suggest it was some sort of secret code that if you referred to free trucks, what you really mean is market price. By the time one gets to 116, it's very clear that the judge has rejected that as being the meaning that's been used by free trucks in this contract. And I say he was right to do so.
You wouldn't dispute, would you, that whether or not either of you is right as a matter of construction, the purpose of leaving the price open was because the market value of the product changes over the years. And so the parties wanted to protect themselves against extremely volatile movements in that price by leaving it to the December of each year before the price for the next year is fixed in some way. So in some way, it's to cater for market condition movements, isn't it?
My lord, I would agree with you if we were dealing with a commodity like oil that has a well-established market. The price is very volatile, goes up and down, LNG, a commodity like that. But this is an incredibly niche product. There is no relevant functioning market for this product.
So going back to the sentence, the first sentence of paragraph 10. I'm sorry, Mr. Corby, I know it's tedious if judges do this, but I think this is quite important. You're saying that is not a description of what was happening in this case. It was a description of, in general terms, summarising, as it were, in outline, introduction, right? So which part of the first sentence of paragraph 10 is not applicable here? Clearly, the invoicing price remained constant.
Yes.
And the delivery volume varied?
Yes. So it's the final wording, according to the market conditions.
Okay.
In my submission, as the judge later construed, the delivery volume, just talking about the 800 metric tons, will vary or be higher depending on the price the parties agree.
So it varies by your point is in this case it varied it would vary according to what was agreed.
Yes, and neither party suggested that the fixed price for the 400 metric tons was a market price. That was just a price negotiated between the parties that they came to for that sale. There was no suggestion that that was somehow the prevailing market price in May 2018. It was an agreed price negotiated based on each party's own commercial position.
What factors would determine the parties' agreement?
The state of supply and demand.
Well, isn't that the market?
They're individual states of supply and demand. And you're dealing with a product that's grown in different parts of the year. In Brazil by my clients and in Greece by the appellant's clients. And so the point is, this is the judge found in paragraph 7. The utility of Greek wesos is that it fills a gap in the market if you realise that your southern hemisphere production has not been great.
The phrase he uses is market conditions. Isn't that broad enough to encompass these points you're alluding to?
No, my lord, these would be specific commercial factors relevant to the parties. And it will be relevant to how much the parties have available to sell, how much the parties are anticipating will be grown in a certain year, how much demand the buyer will have. And as I say, those are commercial factors to be agreed between them. There is not some market price. It's not like a case where the parties can open up the FD every morning and see what the price of Brent crude oil is and say, well, obviously that's the price we meant to agree. It's incredibly difficult to work out a market price in this case. And in my submission, there is no market price. It's a niche market. Their sales are agreed before production. There are a limited number of buyers. And yes, there will be sales. But it's not a case, for example, where either expert was able to show comparable sales of pulprush and say, well, we can derive a price from the fact we've shown all these sales. It's not that case. It's not a case where there's a functioning market in the sense there's an index they could go to. There was no price that they were able to go to determine that. The price they've come up with, which is labelled the market price, is simply this formula, this rough 70% starting point. Both experts working through multiple sources on FCOJ to work out a rough FCOJ price. And then they say, well, that gives you a price. But it's not a market price in the sense that's a price you can say buyers and sellers out there are paying. It's just a price that's been calculated. A market needs buyers and sellers buying at those prices to show, yes, there's a functioning market.
But it is a measure of the price at which buyers of FCOJ and sellers are buying and selling.
Yes, the FCOJ...
Your point is, as I understand it, that because there isn't a separate identifiable market in wesos, you can't talk sensibly about a wesos market price.
Yes.
And I think my Lord's point, and I'm not sure you've quite met it, is that one of the reasons you might want on both sides to leave price to future agreement is because each side's perception of what was a reasonable price would change with the fluctuations in FCOJ actual sales, of which there was a lot of data, and which we've seen from what the experts said, is a highly volatile market, as one would expect from something that's subject to weather and crop disease.
Yeah,
so the fact that there's no separately identifiable list of market prices for wesos doesn't, I think, meet my Lord's point that one of the underlying reasons for leaving it over to be fixed in whatever way it was to be fixed was because the perceptions on both sides as to what a reasonable price would be by reference to
yes, my Lord. The
FCOJ would change.
The way I would put it, my Lord, is that they haven't agreed the price at the outset, and that is obviously because both of them want to leave it open to be able to agree it later. Yeah. And now it may be that, which is my submission, when I come on to the other terms of the contract, that they've left it open only to be agreed between themselves. Or it may be that they've left it open to be agreed by some objective benchmark. But as I say, the other terms of the contract make it clear that there cannot have been an agreement to leave it to be determined by some other objective benchmark in the absence of the parties' agreement. Broadly for three reasons. These are the reasons I'm developing. One, it has to be done by a certain time. Two, it has to be a precise price, and it has to be known by December, so that they know exactly how many free trucks to produce in that period. Three, there's no arbitration clause. There's not even a jurisdiction clause in this contract to be able to show you that the parties contemplated if they disagreed on what a reasonable market price was, there would be some mechanism to be able to work out what the price was in time. And four, and it is very much my fourth point, it's uncertain. And I say that because the judge sat through 4 days of evidence, read all the evidence, not just the snapshot that's in these bundles, heard the evidence from the experts, and decided, well, there isn't a clearly identifiable market price that the parties can be considering they would have resort to. That's a finding of fact. There's no appeal from that. He was perfectly entitled to come to that finding on the basis of all the evidence that was before him. And so one can infer from that the finding that there isn't a readily identifiable market price, that it's unlikely that the parties would have intended the contract to provide for a benchmark, which itself is very, very difficult to identify, if at all.
Which was that finding?
Yes, can you just show us the finding?
Yes. So I'd start at paragraph 49. And this is where the judge notes the evidence of Professor Katupis, the appellant's expert. And it's the 4 lines up from the bottom. Ultimately, Professor Katupis replied that the market price of pulp wash was not readily identifiable with the words, "No, not at all." And then the findings I say where the judge says that the market price is difficult, or in fact impossible to assess, are at paragraphs 123 to 125. And he deals in particular at 124 with the difficulty of definition of the market price. And at 125 he deals with the fact that the 70% figure is just merely a starting point, and that there are many other factors, and that those other factors are, in a sense, commercial factors. And so that is where he says he can't find a market price.
Well, he says the evidence is that the price of wesos is around 70% of the price of FCOJ.
Yes, and then he goes on, however, the difficulty with this approach is that the price of wesos is clearly not affected only by the price of FCOJ. That may give a suitable basis for estimating the likely price. And my lords, if I can take you all, I wasn't going to do this, but it may be helpful if I go through all the evidence we have in these bundles that was before his lordship that showed you the 70% figure was not set in stone and was very much a rough, approximate starting point. And the starting point is in the supplementary bundle at tab 3, page 23. This is the KSY's expert report, and then the bottom bullet, sorry, it's page 23 of the supplementary bundle. And this is KSY's expert, and he says at the bottom, as a rule of thumb, price wash was a minimum of 70% of the FCOJ price. And then if your lordships go forward to page 27 of the bundle, and the heading issue B just above the bottom hole punch.
Sorry, page.
Oh, sorry, page 27. This is the same report, issue B. The second sentence, he says, pulp wash was the price correlation could be between 65 to 80%. And then he goes on to say someone could say that it would go up to 100%. So we've got 65 to 100%. And my lords, if your lordships can turn forward to tab 4, page 49. And this is the expert report of Citrosuco's expert. And at paragraph 30A, second sentence, he says this, i.e. the 70% figure, is a common starting point in price negotiations. If one goes forward to
just
30A.
30A, so the first 2 sentences. If one goes forward to page 54, we're starting at the bottom of 53. So 51, he says, in his experience, pulp wash might generally expect to achieve around 70% of the FCOJ market price, subject to prevailing levels of supply and demand. In practice, there are 2 principal reasons why a buyer will pay less. Over the page, supply and demand is one of them, quality is another. And then at paragraph 53, he says the price of pulp wash will likely fall below 70% of the FCOJ price. In my experience, it can fall as low as 50%. So potentially on the experts, 50 to 100% could be the correlation.
Just pausing for a moment. The quality variant, is that already taken account of in this contract because of the bricks adjustment?
No, my lord. The quality provision is at clause 6 of the contract.
Yeah.
And there are 4 matters: bricks, ratio, acidity, pulp max. I agree on those parameters, that's already taken into account. But there was evidence there's a lot of other factors in pulp wash: the colour, the taste, the bitterness, which will all have a bearing on the quality. And those would still be in play. And there's also the question about supply and demand. If I can show your lordships Professor Katupis's cross-examination,
But sorry, how if those aren't dealt with in this contract, how can they be variables that would affect the price?
Well, I'm saying they would be variables in the sense they might be a matter the buyer would take into account in a price negotiation. It may say, well, we're not that willing to pay a high price for this pulp wash because in our experience it's bitter and it's the wrong colour. And so that's why I'm saying the agreement for the parties to agree would involve a variety of factors. Some of them may be quality factors outside of the ones here. Some of them will be commercial factors such as supply and demand.
But the parties are hypothetically seeking to agree a price for the 800 metric tons before these factors are known and to both parties, and without those factors being identified in the contract. So how would that make any difference?
Well, they had experience of there are deliveries. The deliveries under the previous contracts are going on at the same time. The parties are receiving, those are the two 2017 contracts being delivered into 2018. And so by December 2018, they will have some idea of the quality of the pulp share receiving. And in that sense, and I'm just saying when it comes to agreeing the correlation, that might be a factor that the parties would take into account in trying to argue over the correlation. And turning to Professor Katupis' cross-examination, if I could ask your lordship to turn to tab 13, page 169. Sorry, it starts, this is my cross-examination, starts on page 168, at the top of page 140. This is my cross-examination on the correlation and the 70% figure. And I put to him those figures I've just shown your lordships from the experts' reports. Then over at page 141, I put it to him, this is line 10, line 9 to 10. Presumably you'd accept 70% figure is not something that's set in stone. He says, yes, yes. Then starting at the top of 142, I put to him a number of emails that were in the bundles showing attempts to negotiate the price of pulp wash, which unfortunately aren't in these bundles. But this gives you an idea of the extent to which this is negotiated between parties. So at line 2, we have a proposal that it be 65 to 68%. Then further down, line 18, I make the point that in the email in question, the party had said it should be less than 65%. Then in line 24, commercial party saying it should be 0.63%. Then we go on down to page 144, where I put to him some of the calculations that have been put forward for the price by KSY, and I say, well, they're using 72.5% as a seller. And he agrees, it's right, yes, that's line 12.
Are these contract prices or negotiating prices?
These were negotiations that were taking place, or pulp wash negotiations that we had evidence of in emails. But they're not contract prices. We don't know whether contracts resulted or if there were, what the figure was. But it's just to show you that buyers and sellers will argue around the figure. And then I put it to him, this is line 17 of page 144. The precise correlation to apply is something that will be part of a commercial negotiation. And he said, exactly. So, my lord, I do say that the 70% figure, which is now put forward as a standard price, no longer meeting the market price or reasonable price case, we're now reaching a new case, it's the standard price, is wrong. It was wrong on the evidence before the judge, and that's why the judge held at 125, it's just a starting point. And there's a second layer of uncertainty, my lords, which is...
Does he use that word? Starting point? Does he use the phrase starting point?
No, he says the evidence is that the price of wesos is around 70% of the price. And my submission is there's little distinction. It's saying the same thing. There may be a rough correlation, 70% in circumstances.
I wonder how much one can get out of negotiations. I mean, take a trade in which it is undoubtedly very easy to identify a market price by reference to Brent crude or something. That doesn't mean that if you look at traders' negotiations, they won't be arguing for something different. If the correct construction is, in the absence of agreement, it's to be a reasonable price or a market price, then you can look at the market price. The fact that in negotiations people are trying to get higher or lower, depending on whether they're buying or selling, doesn't really tell you anything about the existence of a market price, does it?
Well, it doesn't if you're dealing with a commodity like Brent crude. There's a public index. But here, where you're not dealing with anything where there's any public data of any sales or any index, and you're dealing with the narrower proposition of, is there a common, universal, agreed
No, not universal.
correlation?
I don't think anybody is saying universal.
Well, a standard.
A general standard. So if one's looking at what is reasonable, I think that's the case you have to meet.
Yes. After you, Lord.
No, go on.
So, my submission is that, given the evidence that was put before the judge, that he's seen everything, sat through the 4 days of evidence on this point, and he's rejected the notion that 70% provides you with a figure that you can use as a reasonable figure, albeit quite laconically in paragraph 125. That shows you that there isn't, it is too uncertain to use that as a reasonable price. That's firstly because the 70% figure is, there's too much uncertainty about that, and it's always going to be a matter of negotiation between commercial parties, that Professor Katupis said. And secondly, my lord, the starting point for all this is that there's a readily identifiable market price for FCOJ. Again, I disagree with that. And then the third point is that there are other factors that are always going to be involved in any sale of this, and those are inherently commercial factors. And what the court can't do under the guise of reasonableness is step into the commercial fray and decide for itself what commercial parties...
But by commercial factors, you mean the parties' perceived commercial...
Yes, the state of supply and demand in the market and how much pulp wash might be needed for the year going forwards. Those sort of factors.
Well, those are one of the reasons that the judge took for rejecting it, in fact, the very first one he lit upon, paragraph 1, 2, 3, is at the bottom of the page, that because the parties were entitled to pursue their own commercial ends, and the ends might be very different, that itself prevented the requisite certainty being possible. That's perceived own commercial interest, and that begs the question as to whether that was something they were or weren't entitled to take into account. When he gets to 125, he's looking at some potentially different.
Yes, however, my submission, the key
general state of supply and demand is a market consideration, isn't it?
Yes, save for the fact that we're not dealing with a functioning market for a product. We're dealing with bespoke sales for a niche product. Right. Sort of ad hoc sales before production.
Yes.
So it's to speak of a market demand, there are only a few players in this market. There are only a few buyers. There may not be anything such as the market demand. It's what a particular buyer needs because their crop has been failing or their crop has been better and so on.
And the remaining shelf life of the product, could that have been a factor in this case? If it had to be agreed in the previous December for Greek production in December to...
No, my lord, I don't rely on the shelf life.
That wouldn't make any difference.
No, I don't rely on the shelf life.
What about the history of working together?
Yes, the history of working together, that was because the experts' evidence was that this stuff isn't easy to go out and sell to anyone that you don't know. You do have to have some sort of relationship. And so the history of working together may help, may of course hinder, because of the previous relationship. The performance of the previous contracts may be a reason why you think, well, we've had 2 years of their pulp wash now, and now we're less keen to work it. It can cut either way, and you need to have evidence on that. And that's why I say that it was too uncertain.
Do you want to say anything about Ms. Larty's cross-examination of Mr. Appa, upon which she relied, and was clearly, and in fact the judge referred to in paragraph 50, in his conclusion.
If I can just make a point from Mr. Katupis' cross-examination about this is about the FCOJ price and whether actually it's all very easy. You just get a public FCOJ price, you apply the right Incoterms, and lo and behold, boom, you've got a price that you can identify in 5 minutes. That was put to Professor Katupis at page 168 of the bundle. And briefly, my submission to him was, well, Mr. Apple went through 3 sets of official sources to try and come up with a figure for the FCOJ price. Professor Katupis went through a lot of other sources as well to try and come up with a price. And I said to him that it was based on a lot of work and a lot of research by 2 experts to try and work out what the price was. And Professor Katupis replied, this at the top of page 137, line 6. Yes, and a lot of informal information. Informal because there are very few sources of information. So we had to rely on informal sources. Companies don't disclose the real, the full price, yes. So again, the FCOJ price is not something that's on an index that can be identified in 5 minutes. It's something that took these experts a lot of time going through a lot of formal and informal sources to try and come up with a figure. And that's why I say here we are.
Well, is that right? Ultimately, Professor Katupis agreed with Mr. Apper's figures. He didn't maintain his own. And Mr. Apper's figures were based on 3 clearly identified, published sources, one from the US Citrus, one from the trade magazine I've forgotten the name of. All readily available sources. Mr. Apper's figures didn't depend upon having to root around in a lot of research, did they?
No, I agree that Mr. Apper was able to get to the answer quicker than Professor Katupis.
Well, and Professor Katupis abandoned his own figures and just agreed with Mr. Apper.
Yes.
And did you, sorry to forget, did you cross-examine Professor Katupis at all to the effect that he didn't really have any expertise in this area at all, being essentially a Greek management consultant?
Yes, I did put that to him. But
it surprised me if you hadn't.
Yeah. He did maintain, though, that he had experience from working in a bottling company and that gave him, he'd sat in on enough negotiations for other commodities to be able to give
Coca-Cola, was it?
Coca-Cola Hellas, yes, my lord. I did put that to him. But as I say, I accept there's a spectrum when one is trying to deal with the market price. At one end, you may have the index for something like Brent crude. It's readily accessible. This is towards the end of the spectrum where it's harder. It's going to take a lot of time, a lot of resources to try and work out a price.
Or what, sorry?
For both the FCOJ price and then for the price of pulp wash that you're going to say should be applied at any given moment. And I just say take a step back. The judge sat through the evidence and he didn't come up with an alternative figure. He very helpfully went on over to decide other factors of the case. But he didn't say if I'm wrong, the market price was X. And I say that's because he wasn't able to. Experienced judge after hearing 4 days of evidence. And I also say here we are, 6.5 years after December 2018. Still we don't know what the price was. We've had no fewer than 9 iterations of the price from the appellant. And the prices that a learned friend gave your lordship today are different to the prices of the pleaded. Those are different to the prices that were put before the judge. And I say that it may be a jury point. I tend to think that expression does juries a disservice, but it is showing your lordships that this is not something that is easy to alight upon. I may be in a harder position if there was a pleaded figure right from the off that said this was the price, and their case had never changed on that. And the fact that has changed so many times and the judge has had so much difficulty deciding it shows you that it's uncertain. I quite accept that may not have been enough to get me home, that the courts are well able to deal with difficult questions and to make reasonable inferences to come to a decision rather than throwing their hands up in the air and say it's all too difficult. But I say when you add that difficulty to the fact it had to be by December of the year and the fact that you needed a precise price and that then from December to March all the quantities have to be produced because you know that by December, that shows you that the parties can only realistically ever have considered that their agreement would give them that precise price in that time. There's no mechanism. It would have been very easy to say, if they intended there to be a formula, the open price will be the FCOJ price reported in Food News, 70% of that. Could have said that, and they didn't say that. And in my submission, that's because they wanted to leave it open to themselves to negotiate and agree that price. The interventions are, as ever, very helpful, but I've slightly been taken out of my course. I might work out.
People always say that.
Yeah, right.
I'm not sure how much they read it. Keep going.
I'm sure they don't read it.
Yeah.
Anyway, well, we have interrupted a bit this afternoon. So, Mr. Corby, well, keep quiet.
No, and it's more my own to make sure I don't repeat submissions that I've already made to you in my notes. But there's one other point I want to say about the notion that the free trucks are designed to protect the parties from fluctuations in the market. That can't be right, because in the context of this contract, that would be an entirely one-way bet against the interests of KSY, even if there was an identifiable market price, which I say there wasn't. If the market price was below the invoice price, KSY would be obliged to provide free trucks to Citrosuco to achieve that price. But if the market price went above the invoice price, no matter by how much, 3, 4, 5 times higher, KSY cannot claim more than the invoice price. And there's no way to make up the difference between the invoice price and a price that is higher than the invoice price by the provision of free trucks. So KSY would be trapped into a very uncommercial agreement where the market fluctuations only benefit one party. And in my submission, that would be a very uncommercial and unlikely result.
And slightly on what the parties might have wanted to do in relation to further long-term trading. I mean, on any view, they could agree a particular price, whatever this contract means, and they might choose to do so if the market has gone up beyond the 1600, even though there wouldn't be an entitlement under this contract, because they have an eye to further long-term trading and goodwill and so on.
In my submission, the more likely outcome is that the parties have left it to be agreed, and so if the price does go up above 1600 and they agree, they want to agree a higher price, they will find a mechanism between them to ensure that KSY gets paid the higher price and the free trucks mechanism doesn't scupper them, rather than it being a one-way bet where they're somehow sotto voce trying to bring in a reference to a very difficult to identify market price with the words difference of price and free trucks. Certainly in circumstances where that's not what they did in respect to the 400 metric tons. My lords, that's all I want to say on ground 1A on the construction point. Right. In my submission, the real question is whether, in the event that the parties failed to agree, there was nevertheless an implied price providing for some other price. And if your lordships could return to the grounds of appeal at page 77 of the bundle, the core bundle. And the case on the implied term, there was an implied term implied first by section 8.2 of the Sales of Goods Act, or otherwise, i.e. common law, that the parties agreed that a reasonable or market price was to be paid in relation to the 800 metric tons. And at the outset, however, again I note that the grounds of appeal do not contend that the alleged implied term will arise only in circumstances where the parties have failed to agree a price in the first place. It's not put forward as a default term. But if I could ask your lordships to turn to paragraph 14 of the particulars of claim at tab 8, page 153. Miss Larty took you to this, your lordships, to this earlier. As pleaded, this is 4 lines up from the bottom over to the right. The implied term is pleaded if the parties were unable to agree a price for the remaining 800 metric tons, the defendant would pay a reasonable price, alternatively, if different, a market price. So the grounds of appeal are contending for something different, namely that the alleged implied term was that the price was a reasonable or market price from the off, not a default price if the parties failed to agree.
Is that really what's being argued?
No, my lord, and quite that's. I'm just pointing out what I've assumed, and the case I'm addressing is what was meant to be said, was that in the event the parties failed to agree, then and only then the price was to be a reasonable or market price, and that's certainly the case I'm intending to address. And at the outset, my lords, the starting point is that this is a contract for the sale of goods. And the issue is whether the price has been agreed. As to that, ordinarily in a contract for the sale of goods, if the price is not agreed and left to the future agreement of the parties, there will be no enforceable obligation. Now, as to that, I've set out at paragraph 22 of my skeleton argument the classic statement from Viscount Dunedin in May and Butcher to that effect. And at paragraphs 23, I've set out 3 statements to that effect from the leading textbooks, Cartwright, Chitty, and Benjamin. I don't intend to repeat those, but I would like to show your lordships 2 more general statements to similar effect about the specific context of sale of goods and price. The first, my lords, is tab 11, the authority bundle. This is one of my learned friends' authorities, Beer and Bowden. And this was, as my learned friend explained, a case containing a term in a lease for a rent to be agreed, which was held to be enforceable by implying a term that the rent payable was to be a fair rent. If your lordships could turn forward to page 99 of the bundle, 527 of the report. The general statement I draw your lordship's attention to is from the judgment of Lord Justice Geoffrey Lane, who said he agreed, I agree that it should be a fair rent. And then he goes on, had this been a contract of sale or an ordinary commercial contract of some sort, there would be a great deal to be said for the view that from the date of the first rent review in March 1973, the contract was void for uncertainty, the parties having failed to agree on a vital term of the contract. And the second general statement that I wish to show your lordships is from the supplementary authorities bundle, tab 1. And this is a case in the Court of Appeal called the Didimi, which concerned a time charter party where there was a provision for an equitable adjustment of hire to be agreed by the parties based on the speed and consumption and performance of the vessel. And what the court held was, even if the parties didn't agree, because it's an equitable adjustment, that's an objective standard, and the court could decide what the adjustment would have been. But for present purposes, I'm interested in what Lord Justice North said at page 12 of the authorities bundle, page 118 of the report in the right-hand column, the second paragraph up from the bottom. Said, I desire to emphasise that my view of this case depends wholly on the parties having prescribed a standard, by reference to which their agreement is that a decrease was to be made. In this bit, I do not intend to suggest that an agreement for sale, lease, charter, or whatever at a price, rent, hire, or other sum to be agreed between the parties to the agreement could be one to which the law would give effect. Lords, with those general observations in mind about sale of goods, cases and prices, I now turn to look at KSY's case based first on the Sale of Goods Act. If I could ask your lordships to turn up tab 2 of the authorities bundle. And this is the section 8 of the Sales of Goods Act. It's in 3 parts. Part 8.1 provides the price in the contract of sale may be fixed by the contract, and this is the bit I'm interested in, or may be left to be fixed in a manner agreed by the contract. 8.2 then says where the price is not determined as mentioned in subsection 1 above, the buyer must pay a reasonable price. And then finally, section 3, what is a reasonable price is a question of fact depending on the circumstances of each case. And if your lordships turn back to tab 1 of the authorities bundle, and page 3, your lordships have section 8 from the original Sales of Goods Act from 1893, which is in materially similar terms, 2 clauses instead of 3. And I show you that, my lords, because I want to show you the decision of the House of Lords in May and Butcher and the King, which concerned that earlier version of the Sale of Goods Act. And that is at tab 7 of the bundle, my lords. In brief, there was an agreement for the sale and purchase of tentage, which referred to excess war supplies from the First World War that the government was trying to sell. I've already shown your lordships clause 3 that showed the price for that would be agreed upon from time to time. That's page 41 of the authorities bundle. And in short, the seller said that this was an unenforceable agreement to agree, and the buyer said that the price was to be a reasonable one under the Sale of Goods Act. I could ask your lordships to turn to the speech of Viscount Dunedin at page 45 of the authorities bundle. which we've already seen earlier this morning. And in particular, halfway in the upper line on the left-hand side, over on the right-hand side, I draw your Lordship's attention to the passage starting "no doubt." And what Viscount Dunedin said in his speech is, "No doubt as to goods, the Sale of Goods Act says that if the price is not mentioned and settled in the contract, it is to be a reasonable price." The simple answer in this case is that the Sale of Goods Act provides for silence on the point, and here there is no silence because there is a provision that the two parties are to agree. And then, my lords, one part of the speech of Lord Warrington on page 46, to similar effect. This is in between the two hole punches. Lord Warrington makes 2 points. First is he says that this case is to be treated on the same footing as if there had been no fixing of the price, as if the contract had been silent as to the price, and the law may then imply a reasonable term. This is the third paragraph up from the bottom. But in the present case, the facts preclude the application of any such principle. So again, acknowledging the principle is there has to be silence. Then he goes on, to do that would not be to imply something about which the parties have been silent. It would be to insert in the contract a stipulation contrary to that for which they have bargained to give them, not the result of their own agreement, but possibly the verdict of a jury, or some other means of ascertaining the stipulated price. Again, the other means of ascertaining doesn't matter whether it's a reasonable price, market price, whatever the other means are, they're being given something that's different. And he goes on, to do that would be to contradict the express terms of the document which they have signed. Drawing that together, my lords, the open price provision was not silent about the open price. It provided for it to be agreed between the parties. And in those circumstances, the open price was left to be fixed in a manner agreed by the contract. So section 8.1 of the Sale of Goods Act applies, and accordingly section 8.2 does not apply, and no term that the price was to be a reasonable price can arise thereunder. As Viscount Dunedin put it, the Sale of Goods Act provides for silence, and here there is no silence. That is what the judge held at paragraph 121 of his judgment, and he was correct to do so. In my submission, there are two consequences from that. The first is that this means that there is no basis, nevertheless, to imply an identical term, in fact, at common law, that the price was to be a reasonable price. If such a term does not arise under section 8.2 of the Sales of Goods Act, the Act cannot be outflanked, in my submission, at common law by implying an identical term, in fact. And to develop that, if I'll ask your lordship to look at the speech of Lord Buckmaster in May and Butcher at the King at page 44 of the bundle. And about 8 or 9 lines down from the top of his speech, it starts, "It has been argued," over on the right-hand side. He says, "It has been argued that as the fixing of the price is broken down, a reasonable price must be assumed. That depends in part upon the terms of the Sale of Goods Act, which no doubt reproduces and is known to have reproduced the old law upon the matter." So in other words, the Sale of Goods Act reproduced the common law position. If I may ask your lordships to go to the judgment in Barton and Morris, which is at tab 22 of the authorities bundle. Lord Legate gave us a history lesson in the Sale of the Goods Act. At paragraph 132, page 405 of the authorities bundle. And briefly in paragraph 131, Lord Justice Legate...
My bundles are separated out, so finding the page is hard. 405.
405.
Which is in the third section.
Yes. And the history lesson starts at paragraph 131, essentially saying that there were some parts of commerce where the courts developed terms from ordinary usage and norms of commerce, sale of goods being one of those. Then at the paragraph 132, goes on to say a familiar body of commercial law which developed in this way is the law applicable to contracts for the sale of goods. By the time the law was codified, in the Sale of Goods Act 1893, the common law had developed a sophisticated set of rules that applied to this type of contract unless a contrary intention is expressed. So it's a codifying statute. And then Lord Legate goes on to note that although Section 8 of the Sales of Goods Act is not expressed in terms of an implied term, but simply as a rule of law, he said nothing turns on that different formulation. There's no difference in substance between a rule which says that there is an implied term of the contract that the buyer must do X, and a rule which simply says that the buyer must do X. And at the bottom of that paragraph, the drafter could equally well have adopted the device of providing that such an obligation is an implied term of a contract of sale. Now, my submission, it follows from that in cases to which the Sale of Goods Act applies, as a matter of principle, if Section 8.2 cannot provide a term that the price for the goods was to be a reasonable price, an exact same term cannot be implied in fact at common law. If that were permitted, the Sales of Goods Act would not be a codifying statute at all, at least on the question of price. Alternatively, if the position cannot be put so high, in any event, in circumstances where a term cannot arise under Section 8.2 because the contract has provided a price for the purposes of Section 8.1, it would be inconsistent with the terms of that contract to imply a reasonable price on another basis. See the speech of Lord Warrington in May and Butcher. In other words, what amounts to inconsistency for the purposes of Section 8.2 of the Sales of Goods Act must also amount to inconsistency for the purposes of implying a term in fact. In brief, therefore, KSY is wrong to say that Section 8.2 of the Sales of Goods Act applies to provide a term that the open price was to be a reasonable price. And it follows from that an identical term to that under Section 8.2 of the Sales of Goods Act, providing for a reasonable price, cannot be implied in fact. Now, it may be said, and I anticipate that it will be said, that Foley and Classic Coaches is an example of a case where there's a contract that looks very similar to a sale of goods contract, and the court nevertheless implied a term that the price be a reasonable price. If I may address that, Your Lordship.
Yes. Do you want us to get Foley?
Foley is yes, tab 6 of the authorities bundle, page 25.
Yeah.
And briefly, in that case, the plaintiff agreed to sell a plot of land to the defendants, which was subject to certain conditions. One of those conditions was that the defendants would enter into an agreement with the plaintiff as to the sale of petrol on terms agreed. The plaintiffs ran a petrol station adjacent to the land that they were selling, and the defendant intended to run a coach business from the piece of land it was buying. The land was conveyed to the defendant, and on the same day the parties entered into a contract of sale for the petrol, clause 1 of which provided, this can be seen on page 28, that the vendor shall sell to the company, and the company shall purchase from the vendor all the petrol which shall be required by the company for the running of their said business at a price to be agreed by the parties from writing in time to time. So that's at page 27, my lords, just underneath. And if your lordship turn over the page, then we have the arbitration clauses at clause 8 at the top. And so the defendants bought their petrol pursuant to that agreement for 3 years at prices charged by the plaintiffs in accounts delivered to him. And then after 3 years, as the judges noted, perhaps because the defendants had a very clever solicitor who was aware of the decision of May and Butcher, the defendant turned around and said that the petrol contract was unenforceable as it contained an agreement to agree. So 3 years of buying petrol, then all of a sudden they turn around and say, actually our whole agreement was unenforceable. And the Court of Appeal rejected the defendant's case and held that in the absence of agreement on price, it was an implied term of the contract that the petrol was to be sold at a reasonable price, and that if the parties could not agree on a reasonable price, then an arbitration was to take place to decide that. And in so doing, my lords, the court distinguished May and Butcher. But the basis on which they did so is key. In summary, notwithstanding that the contract for the sale of petrol may have been thought to be a sales of goods contract, or at least like a sale of goods contract, that is not how it was treated. In implying a term that the price was to be a reasonable price, notwithstanding the presence of an agreement, Lord Justice Scrutton did so by analogy from the brewing industry in the case of a tied house. And if your lordship turns forward to page 34, starting where the line on the left-hand margin starts.
Yes.
It says, in the present case, the parties obviously believed they had a contract and they acted for 3 years as if they had. They had an arbitration clause which relates to the subject matter of the agreement as to the supply of petrol. And it seems to me that this arbitration clause applies to any failure to agree as to the price. and this is the key bit, by analogy to the case of a tied house, there is to be implied in this contract a term that the petrol shall be supplied at a reasonable price and shall be of a reasonable quality. Then your Lordship's turn forward to page 39 of the bundle.
Well, Justice Scrudden had dissented, hadn't he, in May and Butcher, in the Court of Appeal?
Yes. If we turn to, Lord Justice Scrutton had been in the Court of Appeal that was overturned in Hillis and Arcos because he felt he was bound by May and Butcher. At page 39, we have the judgment of Lord Justice Moore to the same effect. If we start by the hole punch, about 12 lines down.
On 39?
On page 39.
Thank you.
It starts with the line, in coming to this conclusion, to the conclusion to imply a term, I am following the old established rule in the case of a tied house, laid down in Cattentoul, and most recently in Courage and Carpenter. In each of these cases, the publican agreed that he would not take beer from anyone except the brewer. The court thought it plain that that meant so long as the brewer was willing to supply beer of reasonable quality and at a reasonable price, and that was expressed in the form of the injunction granted in the second of these cases. And then it's worth, my lords, turning forward to page 40, the end of Lord Justice Moorman's judgment, where at the bottom of the, 8 lines up from the large paragraph on the right-hand side, it says, if the agreement, and he says, if the agreement had stopped short at clause 2, I should have thought that it was unenforceable. Clause 2 is after the provision providing that for the price to be agreed, but the contract must be construed as a whole, and construing it as a whole, I come to the conclusion I have stated. And so it's because there's more than just an agreement to agree. And then finally, my lords, if your lordships can turn to page 36, and we have the judgment of Lord Justice Greer. And in between the two hole punches by the line on the left-hand side, Lord Justice Greer doesn't refer to the cases of tied houses, but he says the facts of this case and the nature of the contract take it outside of the authority of May and Butcher and the King. So the nature of the authority. And my lords, earlier you were shown the decision in Beer in Baldwin.
Yes.
I won't take you back to it because my learned friend took you to there, but that was where Lord Justice Gough said the ratio of that case was not the arbitration clause. And he goes on to set out what the ratio was, and he quotes the passage from Lord Justice Scrutton that I've just shown your lordship about the analogy to tied houses. And so I say there are 2 points to note. First, that the term implied into the contract in Foley was implied by analogy as a legal incident of the kind of contract in question, what would now be called a term implied in law, the type of term that it is an incident of a particular type of contract and will be there unless the parties have expressly provided otherwise. No suggestion there is a term implied in law in this case. And this explains why Lord Justice Greer was able to say that implying a term was not inconsistent with the agreement, because it was already there. It was a term implied in law as an instance of that agreement. And secondly, and relatedly, the basis on which the Court of Appeal were able to distinguish May and Butcher was a difference in the types of contract. So whatever the contract may have looked like, in Foley, it wasn't treated as a sale of goods contract. It was treated as analogous to a different type of contract, the contract between a brewer and a tied house, a brewery and a brewer.
Yeah.
Whereas May and Butcher did concern a sale of goods contract in name and substance. And drawing that together, I say KSY cannot rely on Foley to say that in a contract for the sale of goods where the parties have agreed to agree the price between them, and so there's no Section 8.2 Sale of Goods Act term, the court can nevertheless ignore the Sale of Goods Act and apply a term in fact. There is no analogy between the contract in the case of a tied house or any other type of contract where a term could arise as a matter of law, and as a result, in my submission, our case is indistinguishable from May and Butcher, and it would be inconsistent, as Lord Warrington said, to imply a term that in the default of agreement, the price would be a reasonable or market price. That's the first consequence, I say, of the Sale of Goods Act. Point. The second consequence is a similar one, and it's that if a reasonable price cannot apply under Section 8.2, nor can a term be implied for a market price. And as to that, whereas here a term providing for a market price is being used merely as a synonym for a reasonable price, it would be wrong if the label attached to what is in effect the same term would mean that the effect of the Sale of Goods Act could be circumvented by such a device.
Well, Section 8.2 envisages you can have a reasonable price where there's no market at all.
Yes.
Where it applies, you have to try and determine what a reasonable price is, however difficult, even in the absence of a market.
Yes, quite a lot. And that's a point I'm going to come on to. Here, and briefly to tell you where I'm going to go, my submission, KSY's error, was to only put all its eggs in the market price basket and not give some alternative basis for calculating a reasonable price. And the judge could only deal with the case that was put before him. And having decided that a market price was far too uncertain to identify, it was incumbent on KSY to say, well, if you don't find the market price, a reasonable price would be our costs of production, our costs of transport, plus a margin for profit. And that's why the market price may usually be a measure for a reasonable price, but where it doesn't apply, you have to find some other measure. And that's why the judge shouldn't be read as saying you can never have a reasonable price. He's just saying, on the basis of the reasonable price put to me, I find that that doesn't succeed. And I haven't been presented with any other criteria. I'll come back to that, my lord. In any event, an implied term that the price was to be a market price would be just as consistent with the express terms of the contract as one for a reasonable price. But another way, if an implied term was that the price was to be a reasonable one was inconsistent with the parties' agreement to agree, it follows that an implied term for a market price would also be inconsistent with the parties' agreement to agree. Again, I rely on what Lord Warrington said in May and Butcher on inconsistency, the force of which is not changed based on the label given to the implied term. Inconsistency arises whatever the other means being put forward for determining a price. If I'm wrong, however, I now turn to address the case on an implied term at common law. And the starting point is that I accept that the relevant principles for determining this sort of issue were set out by Lord Justice Ricks in Mammoth Oil, Jet Oil and Octa, and Lord Justice Chadwick in BJ Aviation and Pool Aviation, sometimes for ease of reference referred to as the Ricks-Chadwick principles. The judge set out those principles at paragraph 54 of the judgment, which is at page 94.
Yep.
And in very brief terms, my submission is that having done so, he went on to apply them correctly, and his decision not to imply a term was correct. Before developing that submission in more detail, there are 4 general points to note about the Ricks and Chadwick principles. 1, they are not exhaustive, as Lord Justice Ricks himself said in the opening sentence of paragraph 69, and have been held to set out no more than guiding principles. I don't intend to turn this up, but that was what Dame Elizabeth Gloucester said in Morris and Swanton, which is at tab 21 of the Authorities Bundle, page 357, paragraph 44. But it's unlikely to be controversial that these are no more than guiding principles. They're not set in stone. Secondly, paragraph 1 of Lord Justice Ricks is paragraph 69. Each case must be decided upon its own facts and on the construction of its own agreement. Decisions on other words in other agreements construed against a background of other facts are not determinative and may not be of any real assistance. Third, my lords, turning over the page, paragraph 4 of Lord Justice Ricks's paragraph 69. Where the court has concluded that the parties intended to enter a binding contract, courts are willing to imply terms to enable it to be carried out, but only where that is possible and consistent with the principles on the implication of terms. The court cannot water down the test for implication or bend the rules just because it wants to find an enforceable obligation, and so has to comply with the rules on implication. And so, for example, the court may well not feel able to imply a term into the original bargain on those principles, and the court cannot imply a term which is inconsistent with what the parties have actually agreed. And finally, paragraph 10 of Lord Justice Ricks's summary is a reference to the arbitration clause and the help that may be given by an arbitration clause. And in my submission, it's not decisive, but it is a useful indicator that the parties are given a commercial mechanism that can be quickly operated to get to an answer to resolve uncertainty. And what one can't say is, well, lo and behold, if you don't have an arbitration clause, that's because it's all very certain. And actually, the reason you didn't use an arbitration clause is because you never envisaged that you would actually ever disagree, and this would all be so straightforward, as my learned friend elegantly put it this morning.
Well, I wonder whether arbitration clauses are a bit of a red herring. In current commercial circumstances, the prospects of getting a decision out of a court and getting a decision out of an arbitral tribunal within a particular period are pretty much the same. That it used to be specialist commodity arbitrators, in what we used to call scratch sniff arbitrations, in which you could get a very swift decision on quality or price or those sorts of things, and that may very well be what was had in mind in the older cases about a determination by arbitrators making things sufficiently certain. But subject to your point you've made on jurisdiction, I'm not sure really.
I agree,
you can go to a court or you can go to an arbitrator. It makes much difference which.
We could have a debate between arbitrators and judges as to who are quicker, and I'm not sure we would ever get to the end of that. But certainly it would depend on what type of arbitration and whether the arbitration provides for expedition and all sorts of things. You do have still some scratch-sniff arbitrations on small claims procedures and those things, but the notion that arbitration is universally quicker than the court is incorrect, and I would accept that, my lord. But it also seems that in those cases where the arbitration clause has been relevant, it's to do with the terms of the arbitration clause. Where it's in unusually wide terms, as it was in Foley, that may be an indication that the parties did intend that the arbitrator could decide some matter that wasn't necessarily a dispute or disagreement that could give rise to a claim. But I agree, it will depend on the terms of the arbitration clause. Whereas here, my point is not so much no arbitration clause, there's no jurisdiction clause. This is a contract from May 2018. My clients are Austrian, and they would have been perfectly entitled to say, we have to be sued in Austria. And then we could have had an argument between the parties about where jurisdiction should be. And so that is another reason why I say it shows you there was no way of resolving this quickly, which is why the parties must have intended to agree. Turning back to the correct approach to a job, from the Ricks-Chadwick principles in this case, I accept that at paragraph 80, the judge held that the parties intended to sell and buy 1,200 metric tons of pulp wash, and that they therefore intended to fix a price for a latter. My case is that that intention is not enough. More is needed. If your lordships can go forward to paragraph 85 to 86, in these paragraphs, the judge held that this was a case that the court ought to be willing to imply a term if possible, albeit he held that as any failure to imply a term would not destroy the whole of the parties' bargain, it being common ground that the contract was always enforceable as regards the 400 metric tons sold at a fixed price. He held that the court need not strive too hard to imply such a term, as failing to do so would only undermine part of the bargain. My lords, I'm going to come on to say that that was correct, and up until today I had assumed that that point was common ground. And if I can show you my learned friend's skeleton argument at page 38 of the bundle, starting at page 37. My learned friend says the learned judge rightly held, and then sets out a series of propositions. Proposition C is that this case falls within the territory of cases where the court must strive to assist the parties to preserve rather than destroy their bargain. There's in a footnote, and the footnote says, with the slight caveat of judgment, paragraph 86. And so, my lords, until today, I had assumed it was common ground. But I do say the judge is right, because plainly there is a distinction on the one hand between the case where a long-term contract undoubtedly binds the parties initially, and the question is whether some years into the performance of that contract, one or other parties can turn around and say that the whole thing is unenforceable. That was my learned friend's example. It was a 3-year contract, it's been performed for 1 year. What happens in year 2 if a party says it's not enforceable? That is not this case. In this case, the question is whether only part of the contract is an unenforceable agreement to agree. And that question arises from the very beginning. There's no suggestion that the unenforceable part of the contract has ever been performed. We haven't had 1 year of performance with the open price. It's right from the offset. And in light of that distinction, it's correct that the court need be less concerned to strive to imply a term in the latter case, and it cannot in any event imply a term based on the conduct of the parties, which is the obvious solution in the former situation. So if the court relies on what the parties have done after the contract has been performed, that's obviously inadmissible as an aid to construction. The obvious way to explain those decisions where a term has been implied on the basis of the parties' past post-contractual conduct is that there's an implied term from the conduct. That doesn't arise here, where there's been no performance over a period. The judge held at paragraph 128 that no matter how hard one strives to imply a term as to the price of the 800 metric tons, in the absence of the parties' agreement, it was not possible to do so. And forgive me if there will be some repetition from my case of construction. I will try to avoid that as much as possible, but that's broadly for 3 reasons. 1, that it will be inconsistent with the terms of the contract. 2, unworkable. And 3, too uncertain. Now, as to inconsistency, an implied term that in default of the parties' agreement on the open price, the price was to be a reasonable or market price, would have been inconsistent with the express terms of the contract. Not only, as I have mentioned, with the express agreement that the price would be agreed between the parties, but also in particular with the express agreement that the parties had until December of the preceding year to agree a price, after which deadline had expired, there would be no opportunity to set some other price. So if your Lordship could look at clause 5 again, page 191, court bundle. The open price had to be fixed latest by December of the previous year. That meant that the parties had up until that deadline to negotiate and try to agree such a price. They could negotiate right up to it if they wanted to, right up to midnight. And in those circumstances, there is no window in the contract to allow a price to be determined on some other basis before or after that deadline has passed.
Assuming that by December means by the end of December rather than the beginning of December.
Yes. It doesn't matter which one. Either way, it's a deadline. But quite by December could mean the 30th of November, or it could mean the 31st. But for the purposes of my point, it's just there is a deadline.
Yes, but one has a window before performance is required. The other doesn't.
Yes, quite. But by the 30th of November would make more sense in circumstances where the production period starts in December.
And might be thought to be what by means. You've got to do something by Tuesday.
Agreed. And determining a reasonable price or market price before that contractual deadline would deprive the parties of the whole of the period given to them by the contract to agree. But determining a reasonable or market price after that contractual deadline would be to provide a price too late. It would not have been fixed latest by December of the previous year. Either way, that would be inconsistent with the express terms of the contract. And again, I rely on the fact that there's no jurisdictional dispute resolution clause, so it may take many months to work out even in which forum one would decide a reasonable or market price. My Lord, because time is short, I don't intend to turn it up, and especially because of the point that decisions on other facts, other contracts are not particularly helpful. If your Lordships are looking at the BJ Aviation case,
yes,
a similar point arose in that case, which Lord Justice Chadwick dealt with at paragraphs 27 to 29. And in essence there, just to summarise, there was a lease agreement for 7 years, which provided that the operator of the airport that was being leased had the option within the final 6 months of the lease to serve a notice asking to renegotiate the lease for a new term of 7 years, subject to the price being agreed. The operator served a notice in that 6-month period. They had negotiations, they didn't agree a price, and then the operator refused to vacate the airport and said, well, you can imply a term that the rent rather, would be a reasonable or fair rent. And one of the points Lord Justice Chadwick said is the renewed lease obviously has to be agreed before the expiry of the original lease. So there's a 6-month window to negotiate the price. The parties have the whole of that 6-month period, and the operator can serve a notice on the last day of that 6-month period if he wants. And so there's no opportunity for objective criteria to produce a result in time if the parties fail to agree. And whilst they say different facts, a different contract, the principle is the same in my submission in this case. There's just no window to agree an alternative price. Secondly, my lords, my second point is unworkability. I
Yes.
can be very brief. This is simply that an implied term that in default of the parties' agreement, the open price was to be a reasonable or market price would have been unworkable in circumstances where the open price to be fixed had to be a precise price, again known latest by December the previous year, to enable the calculation of the exact volume of free trucks KSY would be obliged to produce on top of the 800 metric tons and Citrosuco could plan to achieve. But as I've already taken your lordship through, it's not possible to give a 100% precise price, certainly not in a short period of time. I rely on paragraphs 49, 123 to 125 of the judgment.
Just say that again, paragraph.
So paragraphs 49 and then 123 to 125 of the judgment.
Yes. Yep.
That you just can't get a precise enough price in a quick enough time. You can't get a precise price in a quick time. You need to know the exact number so you can calculate the difference in free trucks. And thirdly, as to uncertainty, I've said a lot of what I wanted to say on this already. But all I want to say to that is that in the context of this case, this specific commodity and this contract, a reasonable or market price would have been too uncertain to be enforceable. And now at the outset, I accept there are many examples of courts implying terms that rents, prices, costs, some other matter in different contracts will be at a reasonable or market rate. It's a very familiar benchmark for the court to be asked to decide a case. But it does not follow that this will be true in every case. It will depend on the circumstances and the contract in issue. My lord, the judge was well aware of this. In paragraph 89 of his judgment, at page 104 of the bundle.
89.
89, sorry, page 105 of the bundle.
Yes.
He stated, on the other hand, as the claimant emphasises, the courts are well used to determining what is a reasonable price when there is a contractual obligation to do so. Even so, in this case, having listened to KSY's case as to what a reasonable or market price would have been, on the figures, and gone through all the evidence of what that price might have been, the judge held that on the question of fact as to what a reasonable or market price would have been, he could not identify any such price. And in those circumstances, the judge was correct to hold that the term implying a price that he could not identify in fact would have been too uncertain. In order to determine a price, in the absence of the parties' agreement, the court must be able to do so based on some objective criteria. If I may show your lordships the Mammoth Oil decision at tab 14 of the authorities bundle.
Yes.
And paragraph 73.6 of Lord Justice Rix's judgment, which is at page 136. Yes. Your lordships were shown this earlier. 73.6. Lord Justice Rix starts by there being no evidence that the resolution of a reasonable fee would cause any difficulty at all. So it wasn't difficult in that case. And then a few lines down on the right-hand side, he started, though it's not possible to say that there was a market or list, so there's no market price. But he says that nevertheless he can infer that the user wasn't the only user of the facilities, and in the absence of evidence to the contrary, he can decide that it would be perfectly possible to find some other objective criteria.
Yeah.
Then your lordships were saying that the final few lines, which I draw your attention to, that of course the court are well prepared to make implications as to what will be objective criteria in their absence. They don't shy away from that. The court will try to make those implications if they can, and that's what Lord Justice Rick said. And then one other authority, my lords, Morris and Swanton, which is at tab 21 of the authorities bundle. And this is a case where there was an agreement for a further period to be negotiated for an earn-out provision under a contract, which provided that the further period would be such further period as shall reasonably be agreed between the parties. You see that in page 342. So it's dealing with a period as shall reasonably be agreed between the parties. That's at the bottom of page 342. And if your lordships go to paragraph 28 at page 353, and I accept the point that this is in the context of the period, we're not talking about a price, but starting on the right-hand side, about 8 lines up, secondly, The proposition is that on the assumption that there was such a thing as an objectively reasonable period, that is what the parties would have agreed. And then the final 3 lines, Dame Elizabeth Foster says, the court will have to identify some objective benchmark for determining the reasonable period without reaching an alternative subjective view or descending into the commercial fray. But that is not possible. And then to similar effect, my lords, at paragraph 45, the ladyship noted that line 3, the reality was that all such factors that were being put forward by the party contending for an enforceable obligation there were commercial factors on which the court could not sensibly reach determination based on objective criteria. Now, in the context of a case for the sale of goods, a market price is usually used as an objectively reasonable price. If you say the market price, that normally carries with it the connotation that that's subjective criteria. But as I've shown your lordship, where the market price is not available, some other objective criteria must be identified. Benjamin at paragraphs 247 gives the obvious example of the cost of production. And as I say, the difficulty for KSY in this case is that it relied solely upon a market price being the objective criteria by which to determine a reasonable price. But given the judge's, I say, unappealable findings that there was no such thing as a readily identifiable market price for pulp wash, some other objective criteria would be needed to sustain a reasonable price term. But KSY did not identify any such alternative objective criteria. It had no alternative case based on costs, and it's now too late for it to do so. I ask your lordship to turn forward to page 126 of the judgment. Page 116, the judge noted this in the final 3 lines of page 126. The claimant is not able to identify a sufficiently clear basis for applying that particular test. Here he's talking about a reasonable endeavours test, but in my submission it's the same principle, as to how the price is to be determined, without identifying a way of determining what amounts to a reasonable price. In other words, he says the claimant has, or the appellant has to identify the objective criteria for determining a reasonable price. He's decided that the market, there is no market price, that's not objective criteria. And so this is one of those cases where there should have been some other basis put forward. And so in my submission, it's unfair to criticise the judge because on the basis of the case before him, he was correct to find that resort to a market price cannot provide objective criteria, and he was correct to hold that in the absence of any other objective criteria, and any evidence at all substantiating that alternative objective criteria, that such a term is presented to him is too uncertain.
Right.
My lords, that's all I wanted to say on ground 1B. Very briefly, I want to address your lordships on ground 1A, on ground 1B, which is the reasonable endeavours obligation. This is the alternative reasonable endeavours obligation. And if we can start, my lords, by showing your lordship Swenton and Morris again.
Yes.
Page 354, tab 21 of the bundle. This helpfully sets out the classic statement of Lord Justice Millett in Little and Courage.
Yes. Paragraph 32.
Paragraph 31 on this precise question. And what Lord Justice Millett said is an undertaking to use one's best endeavours to agree is no different from an undertaking to agree, to try to agree, or to negotiate with a view to reaching an agreement. All are equally uncertain and incapable of giving rise to an enforceable legal obligation. My lords, I rely upon that principle. In the second paragraph, too, Dame Elizabeth Gloucester refers to an alternative basis on which such terms are too unenforceable, and that's namely that a party required to use reasonable endeavours is permitted to negotiate in accordance with its own commercial interests. And so at the bottom of that paragraph, her ladyship says, if a party judges that its own commercial interests mitigate against agreeing the relevant matter, it is entitled to take that stance, and there is for this reason as well no enforceable legal obligation to the contrary. And my lords, I rely upon both of those statements as to why such an obligation in this case would be too unenforceable. I also just want to pick up the point that it said that Citrosuco didn't try to agree a price at all, and that it just refused to take any additional profit. I say that's not correct, and I've set out in paragraph 4 of my skeleton argument the references to the emails in the appendix of the judgment that show that negotiations took place between the price. Citrosuco was just not willing to agree the price that KSY was willing to sell at. There's a difference. And in terms of putting forward an alternative price, if your lordship turn to page 58 of the bundle, this is in appendix 2 to the bundle. The email at the top there from the 1st of April.
Supplemental bundle?
Oh, sorry, the core bundle. This is the judge's appendix. That's correspondence. Shall I say what your lordships will see in the references in my skeleton at paragraph 4 that there were.
So sorry, which page?
Page 58. And it's the email at the top, the 1st of April 2020. And it's the bottom line, the bottom sentence talking about the price negotiation, saying we said that maybe we could agree with $200 per metric ton.
Sorry, I'm not at the right page.
Sorry, page 58.
Of the core bundle?
Of the core bundle.
That's your skeleton, is it?
Sorry, page 136. It's the, my apologies, that was the judgment from the judgment page numbering. It's page 136 of the core bundle. It's taken me a long time to get tripped up by that. And it's just the email at the top on the first three. I don't invite your lordships to descend into a factual inquiry as to what negotiations took place, but I do just say the sort of prejudice point that Citrosuco didn't try to agree at all is wrong. Finally, my lords, insofar as KSY relies upon what Lord Justice Longmore said in Petromech and Petrolio Brasileiro at paragraph 36 of its skeleton argument as to a new willingness of the courts to uphold the reasonable endeavours.
You say that was omitted, do you?
I make 5 points about that. And if I may ask your lordship to turn up tab 16 of the authorities bundle.
Yeah.
And turn to page 177. And my lord, your lordship has identified my first point, which is that at paragraph 115 this was obiter, and it was emphasised by Lord Justice Longmore himself to be obiter at paragraph 115. The second point was that the obligation in this case was an express obligation, not an implied obligation. And one turns over the page of paragraph 116, and you can see that from the top of 116 refers to the obligation of good faith contained in clause 12.4. Thirdly, it was an obligation to negotiate in good faith, not to use reasonable endeavours to agree, which related to a minor aspect of the contract in question, namely the reasonable cost, not the price, of upgrading an oil rig to a certain specification, 106 and 117 of the judgment, which cost the court held would have been relatively easy to ascertain in the event that agreement was not reached. It's not a situation that is comparable with agreeing something as fundamental as the price in a contract for the sale of goods. Fourthly, my lords, at paragraph 121, Lord Justice Longmore said that the term in question was part of a complex agreement drafted by City of London solicitors and issued under the imprint of Linklater and Paynes, as Linklaters was then known, and that it would be a strong thing to declare unenforceable, those esteemed lawyers had drafted. And the contract in this question is not a complex agreement. It is unlikely, in my submission, it was drafted by solicitors. I say that because the inapt reference to the governing law being that of the UK being a bit of a giveaway. That's at page 194. And fifthly, over the page on paragraph 121, the top of page 179, Lord Justice Longmore did not hold that the clause was enforceable, but simply that Walford and Miles did not bind the Court of Appeal to hold otherwise. And in my submission, whatever the correctness of what Lord Justice Longmore said in Petromech, that does not justify a conclusion that an implied term that the parties in this case were to use reasonable endeavours to agree a price would be enforceable. On the contrary, it's plain that it would not be. Unless I can be of any further assistance, those are my submissions.
Thank you very much, Mr. Corby. Yes, Ms. Larty, what do you want to say in reply?
Only a few points. All right, let me start with the words used. So this comes out of a question that came from the bench about the words used in the contract, which are price to be fixed. So, and whether that indicates that there will be a negotiation or not, essentially. And in my submission, price to be fixed, I didn't get to my construction argument in my initial submissions, but one of the arguments I made at trial was that fixed doesn't necessarily mean agree, and certainly doesn't necessarily mean agree taking into account one's own commercial interests. And if one looks at the language, and I'll just give you the references in some of the other cases, in F&G Sykes, the language was may be agreed, and that's in the Authorities Bundle, tab 8, page 47, and there was still an implied term. Beer and Bowden shall be agreed, and there was an implied term, Authorities Bundle, tab 11, page 95. BJ Aviation, further period of 7 years subject to the renegotiation, no implied term. And then if one looks at TK Tankers, for example, and this is at tab 20, and this again is not a case about price. This was about the sale of basically a shipbuilding contract, and there were options to buy further ships, I think, and the uncertainty was in relation to a notice period. And the relevant clause that I'm going to be looking at is, I think, at page 271. I hope I've got that right, of the Authorities Bundle. Yes, column 1 for delivery. Delivery dates for each of the optional vessels shall be mutually agreed upon.
Mutually agreed.
And then importantly, but STX will make best efforts to have a delivery within X, Y, and Z. And then when one gets to Mr. Justice Walker's analysis at page 200, one sees that he says, generally, as it seems to me, nothing in clause 4 of the option agreement envisaged any inhibition on TT acting in its own interests.
Para 200.
Apologies, yes. Tab 20, page 300 of the Authorities Bundle, para 200 of the actual judgment. STX was to use best efforts. It is, and then if you look at the end of paragraph 201, what was said about best efforts seems to me implicitly to recognize that the contrasting interests of the parties precluded the identification of a delivery date on the basis of what would be reasonable. So the idea that you might not agree is inherent in the language used in the contract, and then it comes back at the end of paragraph 203, where the best efforts is plainly, in my view, part of the process of seeking to agree upon an essential term. It is very different from valid and enforceable obligations to use best efforts to achieve a result. So the point I'm just taking out of this is that to be fixed, there's no caveat, it is to be fixed. It's not maybe will be fixed or use your best efforts to fix, it is to be fixed. So the wording, the language of the contract in this case, unlike the language in TK Tankers or BGA Aviation, for example, does not reflect the idea that there may not be an agreement. And then the other thing while I'm in TK, which is on a separate point, but while I'm here, at 206, the end of, so paragraph 206, they're talking about whether this is a one-off case. So this is where the judge is trying to figure out whether there's sufficiently objective criteria. And I think that's Potter in Phillips Petroleum, which is referred to earlier in the judgment. Potter's observation that the court is frequently willing to resort to a standard of reasonableness when determining matters which are readily accessible by reference to the market. By contrast, the present case falls clearly within Lord Justice Potter's description of a one-off case, might legitimately operate in the mind. So in my submission, I know my learned friend says this is essentially a one-off case, but in my submission, this is not a one-off case because there obviously are these criteria, 70% of the FCOJ price, which unless you're in a situation where you actually don't want the product, so you're only willing to pay a deep discount for it, you're going to pay 70% of the FCOJ price. And that is what the experts said. And while I'm talking about that, this idea that I should have pleaded the cost of production or some alternative criteria, well, if I had, my learned friend would now be saying that that was a lawyer's construct and that I wasn't implying a term by reference to the evidence, because there was no shred of evidence to suggest that in this wesos market, anyone ever priced anything by reference to the cost of production as opposed to the cost of the FCOJ price. As to the appellant's expert, my learned friend placed a lot of reliance on KSY's expert, and as it was pointed out from the bench at trial, my learned friend spent a lot of time undermining KSY's expert's expertise, and it is fair to say that by closing submissions, we were both relying on
Mr. Appa.
And it is actually recorded in the judgment, and this is at paragraph 43, so tab 6. Professor Katoupis.
So, sorry, 43.
My apologies, paragraph 43, page 91.
Thank you. Yeah.
Professor Katoupis had not personally negotiated contracts involving the sale of orange juice or wesos. And in those circumstances, it was perhaps unsurprising that we were both relying on Mr. Appa's evidence, which in my submission is more than sufficient to show the relevant objective criteria to make good my case. This is a small point, but a point was made about my skeleton argument, about the slight caveat. And this is core bundle, the skeleton arguments are in the bundle, but in any event, it's footnote 19 to my skeleton argument, and I'm of course referring to the caveat that the judge made there, so I didn't want it to be said against me that I was overstating the judge's finding. I'll get on to the silence point and SOGA last. BJ Aviation, a point was made that in BJ Aviation, the court relied on the fact that there wasn't time for that sort of identification via some third party or the court.
Yes.
And that is true in BJ Aviation, obviously very different wording subject to renegotiation. So they're sort of envisaging some sort of negotiation. Whereas what I'm saying here is that that was not envisaged because no real difficulty was envisaged in fixing the price. And I see that my learned friend took you to that email exchange about the US dollars 200. And again, it isn't really the time or place to get into sort of detail about this, but if one looks at what is said there, we said we do not need or want to buy from them, and then potentially offering 200 US dollars, which I think my learned friend said was not a serious number at trial, but in any event, this is not the time or place for that. The judge did not say he couldn't identify a price. This is important. He did not say he couldn't identify a reasonable price, nor did he say he could not identify a market price. He said he wasn't going to imply a term, and I don't think it is correct to say, well, the reason he didn't go on to then say X, Y, and Z is because he couldn't identify a reasonable or market price. We have no idea. So if one looks at paragraph 124 and 124, 124, I've dealt with the list at A to D, etc. already. At paragraph 125, the reality will clearly depend on a series of other factors. So general supply and demand in the wesos market, which is reflected in the market prices already. The remaining shelf life of the product, irrelevant in a contract where the
price is fixed ahead of production.
Well, and the sale is fixed ahead of production.
Yes.
So, yeah.
So
the firm, if I can call it the firm commitment to buy,
is pre-production.
And the likelihood that the parties will only contract if they have a history of working together. Well, they have contracted. So whether they now regret that decision is neither here nor there. And the only other thing I feel I need to briefly address is Section 8 of the Sale of Goods
Yes.
Act. And I think this is quite a bold argument from my learned friend, because what he is saying is two things. One, I cannot have the Section 8.2 implication if the contract says price to be agreed. Let's just use a simple example. Contract says price to be agreed. I can never have the Section 8.2 implication, even if on a true construction of the contract, that meant that was not inconsistent with an implied term that a reasonable price be paid. And more than that, he says, I also then can't have an implied term as a matter of fact. So even if, as a matter of fact, ignoring the Sale of Goods Act, it would have been appropriate, using the Ricks-Chadwick principles, to imply a term for a reasonable price, and we wouldn't have fallen foul of, we wouldn't be therefore falling foul of paragraph 23 of Lord Justice Chadwick's test in BJ Aviation. So it is appropriate to imply a term for a reasonable price, and because price to be agreed in the context of the particular contract isn't inconsistent with a reasonable price being agreed, essentially because on a true construction of the contract, the parties were agreeing to be bound by those objective criteria, because the reason they left the price open was to allow it to fluctuate with the market price, for example. Even then, I now cannot have my implied term for a reasonable price because of the Sale of Goods Act. So the Sale of Goods Act, Section 8.2, which was undoubtedly put in, and I'll show you that, was codified to codify the parties' implicit intention to contract at a reasonable price. That now precludes me from arguing that on a true construction or in the circumstances of a particular case, that's what the parties agreed despite saying price to be agreed. In all other aspects, in all other contexts, I can still argue that. High rent, shipbuilding contracts, etc. But in the sale of goods, if the contract says price to be agreed, the court cannot ask the question, is that inconsistent with an agreement for a reasonable price to be paid if none is agreed? And that must be wrong. That there's nothing in May and Butcher to suggest that's the case. May and Butcher was not about a case where there was where the court found there was an agreement to purchase. It's a case where the court found there was no contract at all. And if one looks at the cases that come before the Sale of Goods Act, to just understand where Section 8.2 comes from, we've got two in the authorities bundle. And if one looks at Valpy and Gibson, for example, which is at tab 5, page 24 of the authorities bundle. So this is pre-Sale of Goods Act.
Yes.
But the omission of the particular mode or time of payment, or even the price itself, does not necessarily invalidate a contract for sale. Goods may be sold, and frequently are sold, where it is the intention of the parties to bind themselves by a contract which does not specify the price or the mode of payment, leaving them to...
Where are you reading from?
Oh, apologies. There should be a line next to it. It's at the top of the page. So page 24 of the authorities bundle, tab 5, page 749 of the judgment. Starting but the omission.
Yes.
And then someone's actually helpfully put some
Square brackets.
Yeah. And we think the evidence in this case shows that the parties intended to bind themselves by a contract of sale at the specified price, leaving the mode of payment unexpressed and to be determined by what was reasonable or what should be agreed between them. And all I'm saying is that's where Section 8.2 comes from. So Section 8.2 comes from a place where the court is trying to codify the fact that even if the parties say nothing about price, then they may be taken on a true construction of the contract, implied terms, all of that stuff, to have agreed a reasonable price. And that is what Lord Justice Chadwick is saying in BJ Aviation. He is saying, even if you have a phrase to the effect of price to be agreed, that is not necessarily inconsistent with the party's intention to contract at a reasonable price. And that can be expressed as agreeing to contract at a reasonable price if no agreement is reached, or it can be, as it was in Sudbrook, expressed as just agreeing to contract at a reasonable price. So with respect, I do say my learned friend's argument on this is bold, certainly insofar as he's saying that the sale of...
Will you say he's wrong?
Yes, I do say he's wrong. I say he's wrong on both points. It would mean that the effect of Section 8.2 of the Sale of Goods Act is that it is harder rather than easier, because of the Act, to imply the term that a reasonable price be paid, whether as a matter of the statute or as a matter of fact. And that is plainly not the intention underlying the Sale of Goods Act. And that's all I intended to say, unless I can assist you further.
Thank you very much, Ms. Larty. Thank you to both counsel and those who sit behind you for the work in this case. We're going to reserve our judgment. In due course, you will receive a draft in the usual way. That's, of course, for typographical correction and other minor factual corrections, not to re-argue the case, please. Please also bear in mind the rubric at the top, the embargo. The judgment is confidential to those to whom it is sent. They should be notified to us. Any breach of that embargo is, of course, a contempt of the court. We would be very grateful if we could have a transcript of the hearing, which has been prepared by your transcribers. In due course, when you get our judgments, that will enable you to, we hope, agree terms of a draft order reflecting our decision. If there's anything that you're not agreed on, we will resolve those issues in writing on the basis of short written submissions. There'll be no need for anybody to attend the hand down, which will be electronically in the now customary way. Thank you all very much.
All right, if